By this point in the series, we've explained how probate is supposed to work.
The court supervises the process, the personal representative manages the estate, and the assets are eventually distributed.
But when disputes arise, families often discover that probate cases don't always unfold the way they expect.
Instead of dramatic courtroom battles, most disagreements play out through paperwork and procedure.
Episode 8.
The procedural traps of probate.
How deadlines and procedure quietly control probate disputes.
Many families assume that probate disputes are decided by powerful courtroom arguments.
But in reality, most probate cases move forward through a much quieter process.
Judges typically rule on what has been filed with the court, not on conversations happening outside the record.
This means the court often sees only a small portion of what families experience during a probate dispute.
Emails, phone calls, and letters between attorneys may never reach the judge at all.
The court usually becomes aware of issues only when a document is formally filed.
And because probate courts handle many routine estates, the system is designed to process cases efficiently.
Most probate cases involve no disputes at all.
Which means the court system is primarily built for straightforward administration.
When a disagreement appears, the process can suddenly feel unfamiliar to families involved.
Questions arise about missing information, delayed paperwork, or decisions that don't seem clear.
And at that point many families begin asking the same question.
If something is wrong, why doesn't the court step in and fix it?
The answer often lies in how probate procedure actually works.
Because in probate disputes, deadlines and procedure quietly control the outcome.
One of the most important things to understand about probate disputes is how action begins.
The court usually does not investigate problems on its own.
Instead, the court responds to documents that have been formally filed.
That simple fact explains why many probate disputes seem to move slowly.
If concerns remain outside the court record, the judge may never see them.
Which means concerns must eventually be translated into formal filings.
The process often looks something like this.
First, a concern arises about the administration of the estate.
Next, someone files a document asking the court to review the issue.
Only then does the court evaluate the request and decide what should happen next.
Without that filing step, the court usually has no reason to intervene.
This is why probate disputes often unfold through a series of procedural steps.
Each step must be completed correctly before the next one begins.
And those steps often involve specific deadlines written directly into probate rules.
Missing one of those deadlines can change the course of the case.
Which brings us to one of the most important procedural traps in probate.
A deadline that quietly determines whether objections will be heard.
And if that deadline passes, the objection may disappear entirely.
In the next section, we'll look at how that rule works.
And why many probate objections fail even when the concerns are real.
Simply because a procedural step was missed.
Probate rules include several deadlines that quietly control how disputes unfold.
One of the most important appears when a personal representative files a final accounting.
That document summarizes the administration of the estate and proposes how assets will be distributed.
When the accounting is served, interested persons have a limited time to respond.
If someone believes the accounting is incorrect, they may file an objection with the court.
The timeline often looks like this.
First, the final accounting is served on interested persons.
Next comes the first deadline.
An objection must usually be filed within about 30 days.
Once the objection is filed, many families assume the court will automatically schedule a hearing.
But in many probate courts, that is not how the process works.
The party who filed the objection must also take the next procedural step.
A hearing must be scheduled within a specific time period.
In many cases, the deadline is 90 days.
If a hearing notice is not served within that time, the objection may be considered abandoned.
even if the original concern was legitimate.
The issue disappears simply because a procedural step was missed.
This is one reason probate cases often revolve around deadlines and filings rather than dramatic courtroom moments.
Understanding these timelines helps explain why some objections succeed while others quietly fade away.
And why careful attention to procedure matters so much in probate.
In the final section, we'll look at what happens when people stop participating in the process.
And why silence can sometimes have legal consequences.
Another reality that surprises many families is what happens when people step away from the probate process.
After months of delays and legal costs, some beneficiaries begin to feel exhausted.
They may decide to stop objecting, stop responding, or simply stop participating.
But the probate process itself does not stop when someone becomes silent.
The estate administration continues moving forward through the court system.
And if deadlines pass without objections, the court may assume the filings are accepted.
The pattern can look something like this.
A filing is served on interested persons.
No objection is filed within the allowed time.
The deadline quietly passes.
And the court may approve the filing as uncontested.
This is sometimes described as waiver by silence.
Not because the court determined the issue was correct,
but because no one formally asked the court to review it.
This can make probate feel very frustrating for families involved.
Especially when concerns exist but the procedure required to address them is complicated.
Understanding this structure helps explain why probate disputes often revolve around deadlines.
And why careful participation in the process matters.
In the next episode, we'll look at another reality that shapes many probate disputes.
Why some probate cases slowly turn into long wars of attrition.
And how the financial structure of probate disputes can influence the outcome.